the client. Ultimate issue, which I just now referred to. And danger of expert shopping. This is the danger which is likely to come. I would go to Malini. Malini would say, well, I apply this particular P300 test, which is scientifically validated, which is much more efficient and better than Farewell's test. This is highly focused. And if I apply this P300 test, this is the conclusion. I don't have any other say. But there may be another person who might say, well, this is all inapplicable. I would prove through my own test that this particular P300 cannot be accepted. Well, perhaps a person who has been subjected to the P300 would go to the other expert, which means to say expert shopping is likely to be, and that's one of the infirmity of the expert evidence. Of course, these are all the distortion, disagreement, exaggeration, expert shopping, lack of quality control, etc., would all affect the expert evidence. I would just quickly take you through the US position, and that is very much relevant for our purpose because the Dauber test as enunciated in US has been referred to by the Supreme Court in the latest State versus Sandhu case, that's Parliament attack case. They have extensively referred to the Fry test and the Dauber test, and based on that, they have also discussed the extent of admissibility of the expert evidence before a court. And therefore, a quick look at this. This would also help us in understanding as to whether the brain mapping and narcoanalysis satisfies these two tests so as to be made admissible before the court. Fry test was a test which was in place till 1993, where the judge was supposed to look into these facts. The court, when admitting expert testimony, deduced from a well-recognized scientific principle or discovery, was supposed to see this factor, that is, this principle must be sufficiently established to have gained general acceptance in the particular field which it belongs. So the general acceptance theory was the theory propounded for acceptance of the expert evidence for quite some time, till in 1993, in Daubert versus Merrildo Pharmaceuticals, the court laid down a new standard for admissibility of scientific expert testimony, focusing more on the relevance and reliability rather than the general acceptability by the specific scientific community. And with respect to the role of the trial judge, Daubert here it's explicit that judges must be more active in screening expert scientific testimony, not that you would be admitting all scientific evidences that are being adduced before you. And therefore, this particular notion, which came up in Daubert, that is the judges as the gatekeepers. They would not allow any evidence, frivolous evidence, to be creeping in. And reliability analysis, these are the non-exhaustive factors laid down by Daubert, in the Daubert, and these are called as Daubert tests. The first question is to be asked is whether the theory or technique has been scientifically tested. You come out with the theory of P300, has it been scientifically tested or not? Then, whether the theory or technique has been subject to peer review or publication. Has it been sufficiently subjected to peer review? Then, the expected error rate of the technique used. Finally, Fry test again, Fry factor, acceptance of the theory or technique in the relevant scientific community. So in addition to acceptance of the theory in scientific community, the Daubert test laid down these factors for assistance of the judges who should find out whether it's scientifically tested, whether there was peer review or publication, the error rate of that particular technique used, and then admit the evidence. Well, after Daubert was decided, the federal courts laid down additional factors, such as whether experts are proposing to testify about matters growing naturally and directly out of the research. So they would have conducted research, not for the purpose of giving expert evidence, but they're in the process of conducting the experimentation. Is that the one which is growing naturally and directly out of that research? They have conducted independent of the litigation. You know, if it is for the purpose of litigation, there is bound to be partisanship, or there's bound to be favoritism, or there's bound to be conducting experiment which is in a specific track to suit the needs of the client. Then, whether the expert has unjustifiably extrapolated from an accepted premise to an unfounded conclusion. which most of the occasions is likely to happen. Then the court said, consider this factor whether expert has adequately accounted for obvious alternative explanations. See, today, immediately after the session, that's the reason why we opened that particular session for discussion. Because these two tests are the tests which should pass the test of constitutionality, legality also, and perhaps that's what we are expecting. The case before the Supreme Court, we do not know what the Supreme Court would say. Hopefully, Supreme Court would apply these tests and then admit or may say that this is admissible. Whatever it is, the expert has adequately accounted for obvious alternative explanations. If there are alternative explanations for the conclusion is because of this, may not be. There was a question asked in the course of our discussion during lunch. What happens if some person has such a great impression during his dream, and that leaves an indelible impression in his mind, and he might respond to that situation in addition to the other response? And perhaps if I ask Malini or Dr. Mohan, they would give a plausible explanation and say, well, these are possible, but it's not possible in a situation of our kind. Our test is foolproof, right? That should be there, where expert has adequately accounted for obvious alternative explanations. Then, whether the field of expertise claimed by expert is known to reach reliable results for the type of opinion the expert would give. Well, these are the additional factors laid down after Daubert test. And Daubert's gatekeeping obligation requiring an inquiry into both relevance and reliability was applied to scientific community in the Daubert case, whereas it was extended further to all expert testimony. So in every expert testimony, Daubert test is being applied to determine whether that's an admissible evidence or not. This is what was decided in Kunho Tire Company versus Carmichael. This background I gave to impress upon you the factors that have been considered for determining admissibility of expert evidence. And in one of the cases, Chandra Devi versus State of Tamil Nadu, the Tamil Nadu court, while looking into the DNA fingerprinting evidence, it did go near application of Daubert but did not apply complete Daubert, where it asked these questions: whether DNA fingerprinting is generally accepted in the scientific community, whether the testing procedure is reliable, whether the tests were performed properly in the case, and whether the conclusion is acceptable in this specific case or not. Do not actually Daubert, some elements of Daubert find place here. As regards admissibility, these are all the issues that could be flagged, which are flagged right in the beginning of our discussion. Article 23, to which response has been given. Article 21, the privacy issues, where they have asserted that it is non-invasive, and even the Supreme Court of US also has said that this pinprick would not amount to an invasion of the privacy. Well, that's what the experts have asserted. Plus, this is a very, very important concept. I don't know whether I will be able to bring the evidence collected from an illegal narco-analysis or an illegal brain mapping. What I mean to say is without the proper authorization. In case, in specific instance, people go ahead with this particular thing and say, you go ahead, let us collect the information, and based on the information that we collect, we're going to collect the subsequent evidences. Well, if that happens, whether it will become admissible under 24 or 27 or not, under the fruits of poisonous tree it is excluded, or is it included according to our Kusmak versus Queen decision of the Privy Council long back. These are the questions which come up. And 161 I need not explain in this particular hall. They said it includes suspects, and therefore those who are subjected to narco-analysis and brain mapping come within the ambit of this 161(2) exclusion. Sharma versus Satish Chandra, the court had said, to be a witness not merely in respect of testimony of compulsion in the courtroom, but may extend to compel testimony previously obtained from him, which means previous suspects were also covered. And this is perhaps the judgment which we always look to while interpreting 23. To bring the evidence within the inhibitions of 23, it must be shown that only that person making the statement was an accused at the time, he made it, and that he had a material hearing on the criminality of the maker of the statement, but also that he was compelled to make the statement. Compelled testimony, as we have been referring to. What amounts to compelled testimony, etc., is to be examined under narcoanalysis as well as the brain mapping. And to which reference have been made frequently, which is the guiding force. Statement of the accused, if voluntary, is admissible and indeed invaluable. And see the third one. Short-term remedies apart, long-run recipes must be innovated, whereby fists are replaced by wits. This is where scientific evidence plays an important role, and this is the point from which we proceed to validate all these scientific evidences. Ignorance by awareness, and the third degree by civilized tools and technology. Civilized tools and technology must replace the third degree, and these two techniques could be brought within the civilized tools and technology method. For this, special training, special legal courses, technological and other detective updating are important, as the court said, and the judge-centered remedies do not work in the absence of community-centered rights. These are the highlights of Nandini Satpathy, which courts thereafter considered. And 23, I think I can skip this because this is implied in the previous discussion. Only focusing on compulsion, usually physical threats and violence, psychic torture, atmospheric pressure, environmental coercion, tiring interrogative prolixity, overbearing and intimidatory methods. Would that also amount to compulsion? And these we have already referred to. In the state of Maharashtra, Ramachandra Reddy, narcoanalysis statement not violative of the Constitution, the court says, whether incriminating or not is known after it is made. Though these decisions have been given, there are also criticism against these decisions, where people have said that the courts have, these high courts have misinterpreted the spirit of Nandini Satpathy. Is one comment coming from the other side. If incriminating, CRPC and Evidence Act prevents its admissibility, right? And therefore, there is no question of whether such a test is to be conducted or not being examined within the constitutional umbrella. Selvi case we have already referred to. Brain mapping test was completed initially, as they know. Indication of involvement in crime was there, and he questioned narcoanalysis test, where the court said 23 applies at investigation level. Since it is another form of investigation, there is no constitutional bar. Because when are we going to know the nature of the statement, whether it's incriminatory or not? It's only after he is subjected to that particular test. Similar opinion of the High Court of Mumbai was taken by the Karnataka High Court as well. Dinesh Dalmia case, Madam has referred to, test being hazardous whether violative of Article 21 or not. This is where the opinion of the scientific community, who explained us in clear terms that this is not hazardous. How quickly one would go to the trance and quickly come back from the trance, though some of you refer to the aberrations of headache and other things. Satpathy case prohibited third-degree methods and not scientific tests, and therefore still it is valid. Brain mapping and narco tests are not prohibited under law and would not amount to violation of Article 21 of the Constitution. So this case, the court was looking at 21 rather than the other provisions, and said, and even it was questioned on the ground of 21. George versus J.S.S, the Kerala High Court, where they said narcoanalysis is similar to blood test. It's similar to blood test, minimum intrusion, and permitted by Kathukalu Ogad is how the court interpreted, Kerala court interpreted. This is the case to which a reference was made. I just go to the third part of it. by using modern scientific method, the police is trying to call out what is there in the subconscious mind. The ratiocination adopted by the Honorable Access Court would support the view that such tests are not violative of Article 21, and those decisions would squarely applicable in holding that other tests can rightly be done, including polygraph, brain mapping, and narco-analysis tests also. You find that the reason why I'm referring to all these cases is continuously the high courts have been referring to the constitutional provisions, and then on the basis of Satpathy and Ogart, they have been validating the use of this particular test at the trial stage. And this is the further extension to which Dr. Mohan was referring to, Section 2053 of the CRPC. Such other tests, right? Though existing generalist tests cannot be applied here, court cannot be averse to scientific tests such as polygraph and other tests which are not mentioned in 53, right? If whether such other tests would include reliable, scientifically true tests or not. And these two fall within that particular area. US position is already explained. This is one case with which, perhaps I would close, to which a reference was made. This was Terry Harrington, an Iowa man who was convicted of murder of security guard in 78. He had already spent 23 years in prison based on deposition in the court by a witness. He had to show that newly discovered evidence was unavailable at the original trial, and the new evidence, if introduced at the trial, would probably change the verdict. That's where the views of farewell was considered. And in this case, the court followed the Daubert standard that US Supreme Court has held as a standard for admissibility of novel scientific evidence. So Daubert test was applied, and the court said that it passes the Daubert test. My only question is, if that test can pass the Daubert test, why not the test developed by the forensic science lab pass the Daubert test? Because that is much more scientific, much more focused, and gives a perfect result. Supreme Court upheld admissibility of evidence ultimately. And they also said it's non-intrusive and accurate mechanism to establish guilt of the accused guilty or exonerate the innocent. It is non-intrusive and accurate mechanism is what the court asserted. Well, friends, as regards its application recently by these courts, in the first case, of course, in the first case, the court said he did not show good cause as to why the tests were needed. So it's extraneous to the brain mapping test, right? Whereas the second one is important for me because the court observed that with respect to the brain mapping evidence, in addition to Farewell's affidavit itself, there was nothing, no other supporting evidence that was produced. Only on the basis of evidence of the expert, affidavit of the expert, you cannot proceed accepting that particular evidence. Expressed doubt as to whether merely based on affidavit that was filed, there could be a conclusion that evidence would pass the Daubert test and hence be made admissible, which means to say it's not mere affidavit, but beyond that some evidence is to be given for validating it. Well, friends, with these, the opinion of Justice Banur Mutt, with that I would conclude my talk, my concluding remark. This is what Justice Banur Mutt says. Having examined and having very closely associated himself with narco analysis and brain mapping processes, he says, in my opinion, brain mapping is like taking handwriting sample, fingerprinting, or subjecting to physical examination, and hence it should be made admissible. He quotes Fali Nariman, who said, "It is time that we recognize the right to silence during a trial is not really a right, but a privilege. And although every accused has a right to be presumed innocent till he is proved guilty, in terrorist-related and other grave crimes, the accused has an obligation to assist the discovery of truth." Based on this, he says, right to silence is not an absolute right, and Mr. Nariman's statement applies to investigation and embargo placed under Article 20, Para 3. Friends, I have not touched upon the issues relating to the Fifth Amendment issues and the 14th Amendment issues under the US Constitution. Plus also, in certain cases where by application of the reasoning given by some of the US court decisions, you'll be finding it difficult to legally accept narcoanalysis as an admissible scientific evidence. There are certain under, of course, Fifth Amendment. However, that could be questioned under 14th Amendment. Fifth Amendment, it would not, it cannot be tested under Fifth Amendment. Well, with these few words, I am of the opinion that both the tests, narcoanalysis test, as is applied now, I would like to modify that, as is applied now, and the brain mapping test. Brain mapping test, of course, it's beyond doubt that coded information, encoded information has been decoded. You just take out information from the brain cells without that being considered as communicative.